Good afternoon. I want to welcome everyone to our webinar seminar today, where we are going to be talking about protecting your family and leaving a legacy, specifically why most estate plans fail and what we can do about it. My name is Attorney Sean Smith, and my law firm focuses specifically on estate planning, and we're hoping this afternoon we can answer your questions, give you some information that you can use when looking at your own estate plan. There is a saying that if you know better, you will do better. So our job today is to give you the information so that you will know what to do, and then in return, you will also do better in preparing your estate plan or even telling others about what they need to do to effectuate a good estate plan for themselves. Again, my name is Attorney Sean Smith, and I'm here with what I like to call my brother from another mother, Daniel Smith. Say hello to everyone.
Hello, everyone.
Today, we're so glad, and we want to thank the Brantleys.
Just want to thank Elder Brantley and Sister Diana Brantley for inviting us at Mount Pisgah with their stewardship department and to bring this wealth of information to them. And we're just glad and excited because they saw this and they saw that there was a need for this information to be given to their church.
So again, we want to thank Sister Brantley, the head of the stewardship department down there at Mount Pisgah Seventh-day Adventist Church. With that being said, since this is a church function, we're going to go ahead and pray as we begin our webinar.
Yes. And I just want to say that Elder Brantley is one of my favorite cousins too. I just want a shameless shout out to Elder Brantley.
We want to thank the Brantley family. Let us pray. Dear Heavenly Father, as we begin and speak about things necessary to make important decisions in our lives, we invite your presence here today. Be with us, Lord. Educate us, Lord, and help us to understand everything that we go over today. Let everyone say amen and amen. Again, I am so excited that we are here speaking with you this afternoon. And again, we have a wealth of information that we want to provide with you to help you make better decisions in regards to your estate plan. As you can see here, I want to start with a personal story. I got a picture here of my family. This picture was taken at the wedding of my wife. The wedding of my sister, Rashay Smith, who is now Rashay Pascal, who they now live in Bermuda. And you can see also in the picture is a picture of my mom and dad in the dark blue suit, along with my two kids who I had at the time. One thing that I want you guys to understand is that what we all know is that family is very important.
Yes.
And sometimes we can take for granted that they are going to live forever. Well, recently, this past Christmas, I had a scary episode dealing with my dad. We went to Philadelphia on a vacation and the entire family was there. And on one particular evening, when we came back from visiting the city of Philadelphia, we were going back into our Airbnb. Me and my kids and my mom went down to the playroom there at the Airbnb, while my dad, along with my wife, were walking back to the bedroom or to our room there, along with my sister. And then while I was sitting down in the playroom watching a football game, I got a frantic call from my sister, who indicated to me that my dad had passed out on his way to the door. And so we ran upstairs. My mother and my two kids came upstairs to see my dad laying out on the floor, very lethargic and pretty much semi-conscious at this point in time. I asked him several questions of whether or not he could hear me or know what was going on. And he did, but he was very lethargic. So we then had to call 911. The ambulance came and he was then rushed to the hospital in the ambulance. And I escorted him, or I was with him or accompanied him on the way to the hospital. While we were in the hospital, we learned that my dad had a bowel obstruction. They did some procedures. He stayed in the hospital for several days. In fact, over Christmas, we had to visit him in the hospital. But that's one of the experiences that I had this particular year that made me understand the importance of establishing a very good and effective estate plan, because we realize that our family and friends and loved ones will not be with us forever. Also, here's a picture of my in-laws. Picture of my wife next to me, along with my sister-in-law and also my mother-in-law and father-in-law. And most recently, my mother-in-law, who lived in South Florida, she was diagnosed with cancer last year. And unfortunately, on May 8th, she passed away. And during that death, I understood the emotional toil that can happen when you lose a loved one, how how you can get depressed, how you can feel down, how you can feel emotionally exhausted. And trying to handle that emotional exhaustion along with establishing whether or not an estate plan is in place, or what's going to happen to the property, or do we need to go through probate, or how are these assets going to be transferred to different individuals. Trying to juggle all those things at the same time is a very difficult task to ask anyone to do. Not only did my mother-in-law pass this particular year, but most recently, I just came back from Bermuda. And in Bermuda last week, we funeralized my granny, and she was 101 years old. To
Wow.
God be the glory, great things he had done. And throughout her entire life, we had a very strong and close relationship. But she lived to be 101, and we were so thankful. However, like the Bible says, she too passed, and that we also had to deal with her affairs and her estate as well. So we realized how important an effective estate plan is needed. Not only that, this year has been particularly concerning due to the things that we have faced. Perilous times have come to America specifically. Perilous times have come to this entire world. We are dealing with a global pandemic called the coronavirus. And we understand that even just in the United States of America, we have had over 214,000 deaths. Specifically in Florida, as of the date of this webinar, October 11, 2020, we have had over 15,000 deaths just in Florida alone. So we understand that COVID-19 and the pandemics also can take a loved one's life. And many of us who are even watching today have lost loved ones due to COVID-19. In addition to COVID-19, we understand that there are additional bearings to play as well when talking about estate planning. Many of you may have loved ones in a nursing home and have to deal with the cost of nursing home, whether or not they're going to be in a nursing home facility or dealing with or be in an ALF, or we call an assisted living facility. These are all long-term care expenses that we need to be planning for. We understand that in Florida, an average nursing home stay can be $10,000 per month.
Say that again.
$10,000 per month. And you need to figure out, how am I going to pay for these costs? How am I going to plan for these particular costs that may come up to a loved one or even myself? I want to give you an example of a famous individual by the name of James Brown. You've heard of James Brown, right, Dan?
I've heard of James Brown.
James Brown died many years ago. But most recently, this past June of 2020, the Supreme Court made a ruling in reference to his particular estate.
It went all the way to the Supreme Court.
All the way to the state Supreme Court in South Carolina. The issue in James Brown's estate was that he was married to this lady. And this lady indicated that she was entitled to some of James Brown's estate, which is an over $1 million estate. The court recently ruled in June of 2020 that this woman's marriage to James Brown was null and void. The reason being is because she was married to somebody previously. Now, this case had been going on through the court for the past 14 years. And in fact, the judge in this particular case was so upset to see that this case was being entangled in the courtroom, understanding that James Brown in his will wanted to give a lot of money to young people in South Carolina and young people in Georgia. He asked the question, have these young people received any of this money? I know that the lawyers have received many of it. So these are the type of issue that you can run into if you do not have an estate plan that's ineffective. Unfortunately, what's going to happen is that most of the attorneys are going to get the money in dealing with your estate plan rather than the loved ones that you want to receive this particular money. We don't want anyone fighting over your legacy. So the question that we're going to ask today is, what if something happened to you? What if something happened to you? In doing this, in doing estate planning, we understand that there are 6 major concerns that we understand that people have. 6 major concerns. And we're going to look at these 6. The first concern is that individuals want to pass on their hard-earned wealth without government or court interference. They don't want the government telling them what to do with their hard-earned wealth. They don't want the court coming in and deciding where their money or where their legacy goes. The second concern is they want to avoid unnecessary taxes and fees. Number three, they want to avoid going broke from nursing home costs and other crushing medical expenses. They don't want to use up all of their money in a nursing home or you lose all their money dealing with long-term care expenses. Number four, they want to, after they're gone, they want to protect their family and wealth from predators and the creditors.
That's very powerful.
Exactly. They don't want after they're gone, they're getting a call from a creditor saying, hey, listen, you owe this particular money, and all that money is sucked up rather than going to the loved ones that they want it to go to. Number five, after they're gone, they want to avoid family members fighting over their money. I'm sure that everyone online has an example of knowing that loved ones were fighting after the wealth of someone that had passed. I gave you the example of James Brown, but I'm sure you can think of specific examples maybe in your lifetime that you've seen. And you don't want your loved ones fighting over your money.
You think that's a big thing, people fighting over money?
The love of money is the root of all evil.
Oh, wow.
In fact, death should be a time that brings families closer together rather than tearing them apart. The number six concern is they want to pass on not only money and property, but their wisdom, their values, and life lessons for generations to follow.
That's very important.
We saw this in biblical times where the old wise patriarchs would pass on their legacy, whether it be through the scrolls or the lessons that they have learned from the Bible. We learned stories about Abraham passing his legacy on to Isaac, Isaac passing his legacy on to Jacob, and Jacob passing on his legacy to his 12 kids. And even today, we see how that spiritual legacy was passed on. But not only that, we also want to pass on a legacy as well. So to sum up the six major concerns, we want no government, no taxes or fees. We want to avoid nursing home costs, no creditors or predators, no family fights over money. And we want to pass on wisdom, values, and life lessons. Now, Ecclesiastes 9:5 tells us the living know that they will what?
Die.
The living know that they will die. This is a prominent scripture and text in the Bible. And the interesting thing is that as believers, we know that we will die, yet we don't take the necessary precautions to prepare us for that day and time.
Say that again.
This is something that we all know. The Bible tells us that the living, those of us who are alive, we know that we're going to die. Death has a 99.9995% success rate in this community. From my research, I can only think of two people who did not pass death. And that was Elijah and the other one was Enoch. So other than those two individuals, we know that we are going to die. And if we know we're going to die, why don't we take the necessary preparations for that particular date and time? Why don't we prepare ourselves for that time? Well, there's some reasons why we don't.
We don't like to talk about that, for one thing.
We don't like to talk about it. But also, we like to procrastinate.
Okay.
We put off till tomorrow what we should be doing today. Procrastination is a big issue when deciding whether or not we should establish an estate plan. Number two is that we don't understand. There's so much involved, so many different technicalities and verbiage that we do not understand. What is a probate? What exactly does a will do? What's a power of attorney? What's a healthcare surrogate? And we are paralyzed through analysis.
I'm so glad that Mount Pisgah
is
being proactive, and that's why we're sharing this information with them today.
Because they're not procrastinating, and we are providing you today with the information and knowledge you need. The number three reason is it's not a what? Priority. It's not that important. There are other things more important. We want to go on vacation. We want to spend time with family and friends. We want to give money to charity, which is also important. But most importantly, I believe, is establishing an estate plan so you can do all of those things.
And leave a legacy to the church.
And have an opportunity where you do all these things and you can be at peace and at rest, knowing that you have a plan in place. As my mother used to tell me, if you fail to plan, you are planning to fail. I thought that was a quote from my mother, but indeed it was a quote from the one and only Benjamin Franklin. If you fail to plan, you are planning to fail. So today we're going to invite you, we're going to encourage you and hopefully inspire you that you will not delay any longer, but you will create a plan to leave a legacy for your loved ones. Well, we're going to look at why most estate plans fail. One reason is that they have poor documents. Maybe it's just a simple will, and we will see as we move forward what happens when you just use poor documents. There's no protection for nursing home costs. You don't fund whatever will or trust you have. You don't have any updates to make sure it stays up to date with what's happening in your life from a day-to-day scenario. There's no remarriage protection, and also your family legacy is not captured. We're going to see specifically how this goes into play in an example that we're going to give you. Now, how many people have at least thought about their estate plan? Have you at least thought about your estate plan? If you have, put a yes in the message bar. Have you at least thought about your estate plan? Dan, what about you? Have you at least thought about your estate plan?
Yes.
You have. Well, thank goodness, Dan, you have at least thought about it.
Mm-hmm.
And we hope many of you, if not all of you, who have at least thought about it. And as your presence here shows and indicates, we can see that you're thinking about it. That's why you're here today for this particular seminar. Now we want to take a look at the life of Bill and Mary Jones. Bill and Mary Jones. Bill and Mary are like most of you who are watching this webinar this particular afternoon. They have a home. They have some retirement accounts because they worked for several years. So they've got retirement accounts with some money in it. They have a life insurance, personal property. They've purchased their home, which they're living in, their homestead. And so when you look at their total estate, it's worth about $700,000 each. So for a total of about $1.4 million. Now, I know oftentimes people may say, oh man, my estate is not worth $1.4 million. But if you really sit down and take a look at all of your assets and things that you have, I'm sure your estate is not too far from that. Just look at your home right now, especially if you're living in South Florida, it's worth probably at least $200,000 or $300,000. So you're almost there already. Now, if you've been working for a long time, if you've got some money in retirement accounts, IRAs, there's some additional money there. Life insurance. Some of you have been wise enough to go ahead and get a life insurance plan that will pay out upon your death. And then you have personal property. Look at your cars, the art, the different paintings and pictures that you have in your home, whether it be a piano or your different personal property. I'm sure you'll be surprised to know exactly how much money is indeed in your estate. So Bill and Mary are much like you and I. But you may be thinking, listen, I'm single. I've never been married. Or yes, I've been married, but my loved one, my spouse has passed away. Or even, listen, I've gone through a divorce, so I'm no longer married. Or you know what? I've been married even more than once. Is what you're talking about today, attorney, does this apply to me as well? Definitely. What we're talking about this afternoon applies to you as well. So pay attention, take a look at what we're giving you, and you're going to be informed with the knowledge that we have to provide for you this afternoon. So again, we're looking at the Jones family. We've got Bill and Mary, and they have two wonderful kids, two beautiful kids, John and Susan. John and Susan. So let's see what happens with the Jones family. Well, Susan was a wise young lady. She's smart. She finished college and graduated university and is working as a CPA in a good firm here in Florida. But then we have John, who's like many of our kids. They don't always make the wisest decisions. And he's made some poor decisions in his particular life. He's gotten involved with drugs. He's had alcohol addiction, and he's had his run-ins with the law and was arrested a couple of times. So he has some issues. And let's just say we are praying very hardly for John. Is that right? So as we look at this particular family, Bill and Mary have some estate plan options. They have a few estate plan options. Number one, they could spend every last dollar. They could spend all they have. In fact, my mother has told me this is the estate plan that she's going to do. She's going to spend every last dollar. Anytime I do something that she doesn't like, or if I get on her nerves, she always warns me, Sean, you're not going to get anything. I'm going to spend all our money and leave you nothing. So that is definitely an option. I wouldn't say it's a wise option, but it is indeed an option. Another thing that they can do in reference to their estate is they could die intestate. Now you may be asking yourself, what is that?
Yeah, what is that?
What is die intestate? Well, let me put you at ease. It is not a venereal disease. It's not a new virus that's coming out to attack anybody. Intestate essentially means you die without a will. You die without a will. In fact, if you are listening right now and you do not have a will and you're to pass away, that is what's going to happen to you. You're going to die intestate. And when you die intestate, the courts will decide who gets what and when. The courts will make that decision based upon the Florida statutes if you die in Florida. So die intestate essentially means you die without a will. Another option is to put everything in joint tenancy. What's joint tenancy? Joint tenancy is how you hold title to a particular property. In fact, most of you, in reference to your houses right now, if you're married, you own your house in joint tenancy. You own your house, you and your wife together, or you and your husband join that home in joint tenancy. So you can go out and put everything that you own and title it in both of your names, and that is an estate plan option. I don't believe it's the best estate plan option, but again, that is an option. Another one, which many of us do, is create a simple will. We go out to the local attorney that we know and say, listen, I want to establish an estate plan. And so I hear something about a will. So they go out and get their local attorney to create a simple will for them. Or they may take it up one next level. Another option is to go and create a bare bones living trust. A bare bones living trust. That's just a living trust with the basic necessities. It doesn't cover your unique situations, your unique issues that are involved in your particular family, but you have what we call a bare bones living trust. A final option is to create a family wealth trust, a complete family wealth trust. And as we go along, we're going to talk more specifically about that. Now, remember we talked about priorities before? This was Bill and Mary's priority. Their first priority is they want to exercise, right? And I can understand that. Since COVID-19, I've been exercising a little bit more, riding on my bike on a daily basis. So their priority, they wanted to exercise. They believed that their body was the temple of God, and they wanted to make sure that they stayed in good shape. Their next priority was to what? Plan vacation. Don't we all love to go on vacations? Even though now we're dealing with COVID-19, we try to do what we can just to get out, even if it's a staycation. Number 3, they was planning their retirement. What am I going to do during my retirement? Number 4, they wanted to help the needy, which is a very good goal. It's a very good priority. Now, second to last on that priority list was creating a will. And finally, planned funeral arrangements. So remember, we talked about before why we don't establish an estate plan is because it is not a priority. And for Bill and Mary, it wasn't a priority as well. Their last 2 things were dealing with their death. We already talked about Ecclesiastes tells us the living know that they will die. They knew that they were going to die. And so their last priority, unfortunately, was to create a will and plan their funeral arrangements. So what do? They go out to their local attorney and they create a simple will. Let's see what happens with that scenario. Well, Bill, while exercising one day, while running around in the local park or within his community, he has a stroke and he has to go to the local hospital. And as a result of that stroke, we come to find out that Bill becomes disabled. Many of us, as we're listening here even now, can know individuals who have suffered a stroke. And as a result of that stroke, they are disabled. They are in a wheelchair, or physical therapy has to come to the home to help them walk. This is something that we see day in and day out. Now, because he's disabled, he's going to need some help with long-term care. Now, how are they going to pay for Bill's long-term expenses? Well, here are some long-term expenses. Here are some options that they have. They have in-home care, meaning somebody will come to the home to help Bill out, help him go to the bathroom or bathe himself or brush his teeth or wash his face and provide food for him. Also, he can go to adult daycare where he goes to a particular facility for a day and then comes home in the evening. Then there's the option of the assisted living facility, or ALF for short. Then we have the nursing home. Here are all different long-term care expenses that Bill is now going to have to think about because of his disability. And because he only had a will, he has no safeguard for answering these important yet expensive questions as well. So here are 5 ways that Bill can pay for his long-term care expenses. He can use his own money. We've already established that he and his wife together are worth about $1.4 million. They can use some of that money to pay for his expenses. They can buy long-term care insurance. They can apply for limited Medicare benefits. They can become eligible for Medicaid, or they can qualify for something called VNA, Veterans Aid and Attendance. So we like to call that for short VNA attendance benefits. It means that if you are in the Army or Navy, there's some benefits that you can receive to take care of your long-term care expenses as well. So as we look at these options, as we look at these possible solutions, these are all available to Bill. However, if he would have had a trust that we recommend, he would not be so worried about how to pay for these expenses. So unfortunately, as the Bible says is going to happen to all of us, Bill passes away. Now, after he passes away, he needs to do something called probate. Has anyone heard of the term probate? Are you familiar with probate? Have you heard someone talk about this? You've seen this in the news or heard a family member talk about probate. Well, what is probate? What is probate? What happens during probate is several things. One, we resolve disputes. Remember, we're talking about the fighting between loved ones and their legacy. The court will resolve those particular disputes. Another thing that we do during probate is we pay the creditors. People will say, listen, this particular person owes me money and I want to be paid out of their estate. So we're going to pay the creditors during probate. We do an inventory and we appraise the assets. What assets do you have? But most importantly, how much are those assets worth? Finally, second to last is we're going to change title to those assets. Those assets that were just in Bill's name, we're going to change the title of those assets so that they're now in Mary's name. And finally, we're going to distribute those assets. We're going to distribute those assets within the estate as was indicated or dictated by the will that they put together. Now, here's the problem with probate, and this is why anyone should want to avoid probate as much as necessary. The number one problem is that probate can be expensive. Well, what expenses are involved in probate? You're going to have court fees. You're going to have to pay a filing fee in probate court. There are going to be publication and sometimes bond fees associated with probate. And my favorite, you're going to have attorney's fees involved with probate as well.
So what is probate? Is probate a process or is it just something that is actual?
Probate, we'll go back. Probate is a process where we complete all these things that we talked about previously, where we resolve disputes, we pay the creditors, we do an inventory and appraisal of the assets, we change the title to those assets, and then we distribute those assets within the estate. So specifically what happens, if someone needs to go through probate, they're going to hire an attorney who's going to file a particular petition with the court, with the local court where that individual died. After they file the appropriate paperwork, they're also going to file what we call the death certificate, and we're going to establish a probate case in front of the local court where we then go through the process that we talked about before, where at the end of that process, we finally get to distribute the assets within that estate. Now, the problem with that is that, again, I mentioned there's attorney's fees and the court fees and the publication of the bond fees, but also it's time consuming. This is something that's not going to happen overnight, but it's going to take place in months and sometimes even years, as we saw in the case of James Brown.
Wow.
Not only that, it can be open to the public. And third or fourth, there could be multiple probates in every state, depending on where you have property. In fact, I'm familiar with the case right now where we have probates in different countries. So we want to try to avoid those as much as possible. That's the problems you deal with when you have to go through probate. Now, in Florida, their attorney's fees are deemed reasonable, meaning an attorney.
I was just going to ask, what are the, sounds costly, this probate process.
Exactly. Now, Florida statute gives an indication of what we call a reasonable attorney's fee. So when you go seek an attorney, how much can an attorney charge you to do a probate? Let's say your assets are less than $40,000. Then you're looking at least $1,500, which the court will deem reasonable. Now, let's say it's between $40,000 to $70,000. You're looking at around $2,250.
$2,250.
$250. Now, let's say you're between 100,000 to 999,000. Then the attorney can charge you 3% of the estate, and it keeps going up to 2.5%, to 2%, to 1.5%, to over 1% if it's over $10 million. Now, we've got to understand that in most estates, someone at least has a home, and that home, as I indicated before, is worth about at least $250,000, if not more, which is going to have to go through probate. So at minimum, if you have no home, you're looking at around $1,500, and if not even more. In most scenarios, in most case scenarios, you're looking at least $3,000 just in attorney's fees in dealing with going through the probate process and dealing with an attorney. Now, attorney may also charge additional fees, the statute says. If the will is contested, if there's a fight that takes place, you're going to be paying more. If there needs to be a determination of who the beneficiaries are and what the beneficiaries get, that also may cost you additional fees, as well as litigation and even adversarial proceedings. So the fees that I mentioned are just the basic fees, and the attorney can charge even more if there has to be litigation and other arguments that need to be sorted out in the courtroom. So another thing that we want to talk about is death taxes. Right now, based upon the last tax plan that was passed by this government, most estates are exempt from federal taxes if they are less than $11.53 million. So if your estate plan is less than that, you do not have to worry about any death tax. If it's worth more than that, then you will indeed have to worry and think about paying a death tax. Now, when we look at this estate plan, we've established that Bill and Mary's estate plan was $1.4 million. So they're looking at attorney's fees of about, which the court will deem reasonable, at about $30,000, right?
Wow.
Not to include nursing home or long-term care medical expenses, court fees, or even notice to creditor fees as well. Just something for you to take into consideration. Here's a summary of a bad estate plan. There's no protection from guardianship, no protection from nursing home expenses, no protection from probate, and no way to pass on Bill's values and life experiences. Now, let's look at Ralph. This is Bill and Mary's longtime friend and next door neighbor.
Yeah, who's Ralph?
Now, Ralph is a friend of Mary's, and he sees that Mary is sad and she's in mourning because of the loss of her husband. But he also sees that, hey, listen, Mary has a big estate that's going to be coming to her as well. So he comes in and starts to spend time with Mary, and he looks to get married to Mary and try to get all of this money from Mary and maybe even pass it on to his grown children as well. This is something that some of us may want to protect ourselves from. So let's keep it in the family. Let's keep it into your family. A well-drafted estate plan blocks estate transfers outside of the family. It can also require that Mary get a prenup before she goes ahead and marries Ralph. And that can protect that estate, that $1.4 million, so that they are passed on to Bill's children and not to somebody else's children. Now, Mary has the whole estate after going through the probate process, and this is good news for Mary. She's excited. She feels that she has a nest egg of which will take her long in her particular life. In fact, statistics show that a surviving female spouse lives an average of 14 years after the death of their spouse. So Dan, if you die, it looks like your wife is going to live at least 14 years after you.
Good for her.
And we hope that she doesn't have a next door neighbor she's concerned about. But statistics show that Mary's looking to live at least another 14 years. So let's see what happens to her during these 14 years. Now, Mary doesn't live 14 years. She lives another 10 more years. Now, during this time, Mary suffers from Alzheimer's. And I'm sure that many people listening now know of individuals who have their own family members who are suffering from this debilitating disease of Alzheimer's. And because of this, Mary has to be placed in a nursing home. If not a nursing home, who's going to take care of it? Maybe Susan, or maybe her daughter will bring her in, Susan, or maybe her son, which doesn't make all the best choices. I don't know if it'll be a great idea for him to go with her, but these are the decisions that they're going to have to look at now. Here are the plans that they are now going to have to make because they didn't make them before. Where are we going to place Mary because of her Alzheimer's? She can't stay at home alone. The house may catch on fire. She's not able to pay her mortgage. She's not able to pay her light. She's not able to pay her electricity because of this debilitating disease. And now the decision has to be made by the kids to place her in the nursing home. About half of the elderly end up in a nursing home before their death. And because Mary is unable to handle her affairs, she's also placed in a nursing home. And during this day and age where COVID-19 is running so rampant, we understand even the greater concerns about sending someone into a nursing home dealing with this particular pandemic. Now, because Mary cannot make decisions on her own, who will handle Mary's affairs now that she's disabled? Who's going to call the light bill, the mortgage company, or the electricity? Who's going to deal with these issues? There's a court process designed to protect those who are mentally disabled, and that process is called guardianship. A guardian is a surrogate decision maker appointed by the court to make either personal and/or financial decisions for a minor or for an adult with mental or physical disabilities. So if you are guardian for your adult parent or for an elderly person, you can be guardian over the person, or what we call guardian over the property. What that allows is a court proceeding which the court dictates that this particular person now has the authority to make those financial and even medical health decisions on behalf of this particular person. And the reason why they have to go through a court process to do this is because this individual with Alzheimer's is not mentally capable of making those decisions on their own. And so, is anyone out there familiar with the term guardianship? If you are familiar with guardianship, let me see you say yes in the message bar. Dan, what about you? Are you familiar with guardianship?
Yes, I am. Is there a cost involved?
There is definitely a cost associated with getting a guardianship. That's more expenses that you're going to have to pay. Here are some of the nightmares involved with the guardianship. One, there's court control. The court controls and overlooks all the decisions that you make. Not only that, anytime you're dealing with the court, we understand that it can be time consuming. And three, as you mentioned, it is expensive. You have court fees, attorney's fees, and also accounting fees that you have to deal with as well. So this particular family, John and Susan, has to go to guardianship court. Which child is the court likely to appoint? Now, remember, in going through guardianship, it's going to take one of the kids going to see an attorney and filing a petition on behalf of their loved one. And in seeking an attorney, they're going to have to pay attorney's costs or attorney's fees to get this process even started. Guardianships can cost around $5,000. It can be around $5,000 for guardianship. So in the life of Bill, in the life of Mary, Mary passes away, and another probate has to be done for this family. In order to transfer the assets from Mary to her two kids, the kids now have to go back to probate court, right? So after Bill dies, let's estimate that Mary's left with $1,000. She pays had to pay $5,000 for the attorney for the guardianship fee. She had to pay another $29,000 for the probate fee because, remember, based upon the statute before, anything less than $1 million, you're looking at 3%. We haven't talked about nursing home costs. We haven't talked about long-term care costs. And we haven't even talked about guardianship court fees as well. So after Mary dies, she's looking at giving the rest of her assets to her young kids.
That's about $1 million.
About $1 million. Now, one of the things that people are concerned with is that each child will receive a lump sum distribution of several $100,000, right? Clients' biggest concern for their wealth after they're gone is that someone will take financial advantage of their children or their grandchildren. The top three risks that parents worry about when they're gone is that their kids will get divorced and family assets will go to a stranger. Opportunists will take advantage of the kids. And number three, their kids will get in trouble and they're going to have lawsuits and creditors that will come up and suck that money away. Now, when we look at Susan's husband, she was married to a man by the name of Jason. Jason wasn't working as hard as Susan was. And if Susan received an inheritance from her mom and put that money into a commingled bank account. Then if Jason came and asked for a divorce, he's going to ask the court to give him half of that estate, half of that money that Susan got from her loving parents, Bill and Mary. Now Jason is going to argue that he's entitled to that as well, under the concept of what we call in the legal courtroom equitable distribution. Everything needs to be split down the line. Then let's take a look at John. John is a walking liability factor with the decisions and choices that he makes. You know what he does with his money? He goes out and he buys a new car, and we know that he likes to speed and he doesn't like to follow the laws of the land. So we're thinking maybe he will get into an accident. But no, it's not an accident that takes a big chunk of John's money. It's the IRS. It's the tax man that comes out and wants to take a chunk of $80,000 from the estate, or the sum or the type of money that he received from his mom and dad. So bad estate planning, if we look at a summary of all the bad things that have happened to poor Bill and Mary, we know that one, there was no protection from nursing home costs. They had to pay this money out of pocket. There was no protection from guardianship or probate fees, no relief from death taxes, no protection if the spouse decides to remarry, no protection for the estate if the children get divorced, no protection from children from lawsuits and creditors, and there's no way to preserve the family's life values and their stories. There must be a different way. There must be an alternative. And what we want to talk to you about today is that alternative. What is the other option that's available to everyone that's out there to avoid these particular situations in life? As I said before, to know better is to do better. And so we want to give you the option today so that you can do better. Well, what we advise is a living trust. Now, what is a living trust and how does it work? What is a living trust and how does it work? Well, there's some trusts out there, what we call like fast food documents. They're bare bones living trusts. They only address probate, completely inadequate documents. They don't address your specific and particular needs, and it ignores real world issues faced by families today. Your life is unique. Your goals are unique. Your livelihood is unique. Every family is unique with what they're doing. And so you want a plan that meets and fits your unique situation. You do not want a one size fits all. You want it tailor-made, like how I like to get my suits. You want to get a tailor-made suit or a tailor-made trust to meet your particular needs. And unfortunately, if you just go to online and get these free documents, they're not going to meet your needs. And if they don't meet your needs, they're not going to be able to protect you when you need it most. The magic of living trust is how you hold your assets. What is the title to your assets? And what name are your assets in? Let's take a look at how this works. What we want to do is we want to transfer the title into the name of the trust. We have here a family wealth trust. We put joint property into the trust. We put the wife's property into the trust. We put the husband's property into the trust, into what I call a treasure chest or a trust document. Once we put all the items or the assets into this trust, it now then becomes protected. Well, what does that mean for Bill and Mary? Does it change the way and how they act or change the way how they utilize their assets? No. They still have control over their assets. They don't lose control over it at all. They can amend the trust. They can revoke the trust if necessary. They can still buy, sell, and refinance assets if they want to. I'm not worried about new income tax forms, and there's no change in the property or the tax bills. It is held safely within the trust, and it's going to provide them with the protection that they need. Now, so why create a family wealth trust? It's simply what we call a standby device. Protects you in case you become disabled or you die. It avoids court involvement and also protects your spouse, your children, and your grandchildren. It is a protection box for your assets. We may even consider it maybe an ark to say. You put all your items in there and it protects you from all the things that happen out in the community and the world around you. Now, if we go back through the same scenario and see what happens if Bill and Mary have a trust, we see a different outcome. If Bill has a stroke and he has a trust, and he passes away, there's no need for probate court. That All of those assets will automatically transfer to Mary upon Bill's death. He avoids court fees, attorney's fees, no lengthy court process, no public record, and no multiple probates in different states. It's a quick, simple, fast, and easy solution to that particular problem. What about his experiences and his wisdom? We can pass that on as well in the family legacy wealth plan that is provided. What about Ralph? Remember Ralph? But we ain't got to worry about Ralph anymore because we provided in the trust that Mary needs to get a prenup before she gets married to Ralph. So that's now going to protect the children, John and Susan, from Ralph trying to take any money. As I said before, blocks the estate transfer outside the family and requires a prenup. Also, nursing home expenses and liability. With a Medicaid protection trust, nursing home costs can be virtually eliminated. The Family Wealth Trust can protect a portion of the family's assets also from liability. So we can create a specific, what we call Medicaid protection trust that can help you get qualified for Medicaid, but also protect your assets. And in addition, if somebody gets into an accident and somebody wants to file a lawsuit against the family, again, that money is protected within the Family Wealth Trust. What about Mary? Mary gets Alzheimer's, and remember the solution of having to go through guardianship? If everything is set up right, Susan already will have the authority to manage the trust. So there'll be no more court proceedings, no more loss of control, no more delays or expenses. The trust will give Susan the authority she needs to make the decisions on behalf of her mother, and she won't have to worry about guardianship. So there'll be no public humiliation, no loss of control, no time delays, no needless expenses through court fees, attorney's fees, and accounting fees. That's already taken care of in the trust that is established. Now, what about legal fees? No legal fees, but who's going to pay for the cost of Mary's nursing home stay? Now, this goes on to the Medicaid Protection Trust. Through additional means, we can set up a specific trust to help Mary avoid those nursing home cost expenses. So she won't have to look at paying $10,000 per month for her to stay in the nursing home. There is a plan for that. I remember there was a lady running for office who her motto was, "We have a plan for that." And two, whatever your estate plan issue is, there is a plan for that estate plan issue as well. Now, if Mary passes away, she will not have to go through probate because she's established her trust. There's no court fees, no court process, no attorney fees, and again, no multiple probates in different states. And she, again, is also able to pass on her life stories and preserve her wisdom and values for future generations. Now, why do parents worry about what will happen when they're gone? If Bill passes, it goes to Mary. When Mary passes, half will go to John and half will go to Susan. Now, upon this, what we call second death, there are different trusts that we can utilize to help protect both John and Susan from the issues that we looked at before. Now, there's something called a family-centric trust that we can use to protect John, and something called a family access trust that we can use to protect Susan. Let's see how these particular trusts work in their particular situations. Remember the lazy husband that Susan had? Well, if they create a family access trust, once Mary dies, that money will go into the family access trust, which will be protected from the lazy husband. So those funds are no longer commingled, and he will not have access to those funds if he does want a divorce, because they have not been commingled. They're in what we call the Family Access Trust, another particular treasure chest to hold these documents to protect her from the lazy husband. Now, what about John? We're worried about John and the lawsuits and creditor protection. And also, we understand that he also makes some bad decisions in life. Well, what we can do for John is create something called a Century Trust. If we put that money in the Century Trust and we have an independent trustee to restrict John's access to that money, we can now protect him from the lawsuits and also the creditors, right? In fact, we could put incentives in there that if he graduates or gets a full-time job, or if he goes to drug and alcohol treatment or receives counseling for his gambling problems, he can get additional monies when he cleans up his particular act. So therefore, this money is not squandered or lost due to his bad decisions or his bad choices. Some of you may be thinking of your loved ones or nieces or nephews or family members who may need to have a century trust to protect them from the decisions of the young people in their life. Now, there's a 5-step family legacy wealth system that's involved in this particular process. Well, what is that system looking like? If I want to get a trust to protect my family, what are the steps that I need to take? What decisions that I need to make? You're saying, attorney, you told me to know better is to do better. So what do I need to do to make better decisions in regards to my estate plan? Well, how this plan works is that first, there's a personal consultation that is had with the family to find out what plan is specific to their particular needs. That's the first client meeting that's had, which is about 60 minutes, where we sit down and look at your cares and look at your concerns to find out what plan is necessary for you. What tailor-made plan or what trust do you need? Do you need the Medicaid trust? Do you need the Century Trust? Do you need the Access Trust? Do you need the guardianship protection? Do you need the probate protection? We look at all those to make sure that a plan can be created for you. The next thing we do is that the attorneys and staff get together and we draft the particular plan. After we draft the plan, we then say, listen, we need you to bring in all your assets, all your inventory. And we talk about funding that particular trust. And after we fund that particular trust, we have you come in and you sign what we call the formal signing ceremony, funding and plan delivery. Basically, you come in, you sign your documentation, and we provide you with the trust and all the information necessary so you understand what is happening in your particular plan. Then after that, we stay in contact with you, keep you updated with your trust, and answer any questions that you may have in reference to your specific and particular need. We call that the 5-step family legacy wealth planning system. Now, total protection. We talked about guardianship protection, probate and tax protection, divorce and remarriage protection, creditor protection. Many people ask, well, how much is it going to cost typically to get a family wealth trust? Well, typically it costs about $4,000. Now, when you look at that in comparison to the $64,000 that Bill and Mary had to pay for attorneys before, we believe that if the choice is clear, is to get a family wealth trust now to prevent all the issues and concerns that you may have if you do not get a good plan. It's essentially an investment now to get you the protection that you need. It's like an insurance. You pay monthly for your insurance. So if something happens to you, you have the insurance necessary. A trust is kind of like an insurance to make sure you're protected from probate, to make sure you're protected from guardianship, to make sure you're protected from lawsuits and creditors and predators, to make sure your children are set up in a means that they can survive and be successful as they grow older and continue to make wise and decisions as they mature. Now, as we conclude, what's the most important part of your planning? We believe that it's making sure what's most important to you is covered in your plan. What's most important to you is covered in your plan. Your thoughts or your desires are different depending on your needs. Your priorities for what's important is different depending on your particular needs. So as we speak to you, or as you speak to an attorney, make sure that your needs, your priorities are outlined and displayed in the trust or in the plan that you create. So in conclusion, we don't want you to get the bare bones cheap plan that's not going to cover all of your needs and all of your necessities. You want to put a plan designed for your particular family. You want an attorney to create a plan to match what's most important to you. After all, this will be a plan to last for generations. The one necessary ingredient that most living trusts don't have is that they're not funded. Many times people create a trust, but they don't fund it. They don't have their assets in their trust. And if you don't have any assets in the trust, it's just like having a beautiful pen with no ink. It's worthless, right? What should you know about pricing? You want to work with a firm that listens and asks good questions. You want to work with an attorney that you're comfortable with because you're going to be dealing with them for a lengthy period of time. Now, you don't want to worry about having to pay an attorney an hourly fee, knowing that if I call my attorney to ask him any questions, am I going to be billed every particular hour to understand the trust that he's created for me? Also, you want to see if you want to get a flat fee quote before the attorney begins working on your particular case. We believe that that's important for you. So We're able to give out free personal consultations. Now, the most important thing that you need to know about free personal consultations is that you want to schedule an appointment today or within the next 2 weeks. If you're married, both spouse and the husband attend, you want to be able to make a decision either yes or no. And in fact, I didn't talk to you about this before, Dan, but we want to offer individuals a complimentary power of attorney. If you go to our website and enter in your information, your contact information at our website, going to ask them to put that into the screen. If you click on the contact information, we ask that you put your name and also your last name, your email address, and in the message bar, put Legacy Wealth Seminar or Legacy Wealth Planning or Legacy Wealth Webinar.
Or just Mount Pisgah.
Or Mount Pisgah. Go in there and put in your contact information, and there we will give you a call tomorrow, let you know if you're eligible, if you receive you receive the complimentary power of attorney. Go to the website now, put your information in, and you can possibly win a complimentary power of attorney. And since we're on the subject of power of attorney, let me explain that just a little bit. Many times we hear of individuals talk about a durable power of attorney. Why a durable power of attorney is important is because with this particular document, you're able to take care or help your loved ones even if they become incapacitated. Well, what do you mean by that? A durable power of attorney will allow you to go to the bank, deal with the mortgage company, deal with many of the everyday affairs of your loved one when they do not have the capability of doing so. Maybe they're stuck in a nursing home, or maybe they don't have access or even know or understand how to do those things. If you create a durable power of attorney on their behalf, and they have to be within their right mind today and know what they're doing, then this allows you to do many of the things necessary on their behalf. It's one of the most important and essential documents that you're going to need in any estate plan, and that's a durable power of attorney. So I invite you now to click the contact list in the message bar and put in your first name, your last name, your email address, and your phone number. And in the message bar, put Legacy Wealth Seminar, Legacy Wealth Planning, or Mount Pisgah, and we will give you a call soon to let you know if you receive the complimentary durable power of attorney. It's going to go out to one person that registers. I see we have 32 people online. If we can have all 32 people register, that would be greatly appreciated. Again, I want to
go back to the other slide, so that they can the contact slide.
Yeah. Also, if you have an additional questions, you can email Daniel Smith at dsmith@srhslaw. Dan, wave to the wonderful people online.
Hey, wonderful people. I think this is a good point, as well as they're looking at the information, that we can answer some questions, because I know a lot of this information can be a little bit overwhelming, but since we're here, we are taking questions. So if you want to type in your question, we can take some questions now.
Definitely. If you have any questions, we can answer some general questions for you. So you can put those questions into the chat as well, and they'll notify us of what specific questions you have. Also, do not forget to go to our contact page, click the link in the message bar, and put your information. What's the difference between a power of attorney and guardianship? Nydia?
There's a Nydia Nitalda.
Yes, that is an excellent question. What's the difference between a power of attorney and a guardianship? Now, what often happens is that individuals that do not have a power of attorney and they now need to handle the affairs of the loved one is no longer able to make the decisions. They're not in a mental capacity to be able to decide who is going to be their power of attorney. So then they have to go through the guardianship process. So the guardianship process provides the same rights as you would get with what we call a durable power of attorney, right? As you would with a guardianship. But a durable power of attorney gives you that authority and avoids many times the need for the guardianship as well. So that is an excellent question. And remember, you said power of attorney. There's also a difference between a power of attorney and a durable power of attorney. A durable power of attorney allows you to continue to have authority and access even when the person becomes incapacitated. A power of attorney does not allow you or afford you those rights and privileges.
That was a great question.
Great question, Ms. Nydia. Any other questions? Any other questions? And again, as we're talking, we invite you to go to our contact page and
go to our website too.
Go to our website. The contact page is a link to the website.
All right.
Great question. Any other questions that you may have out there?
Any questions for Attorney Smith? Diana Brantley. I have the power. I'll read it. I have a power of attorney for my cousin. If her property is sold, where should I put the money? Attorney Smith.
Diana Brantley, I have the power of attorney for my cousin. If her property is sold, where should I put the money? Sister Brantley, I'm going to
next question too. Answer that question.
Let me answer that. I'm going to invite you to contact us so we can give you a free consultation to talk about the specifics of that particular situation. But most oftentimes, and not knowing the particulars, most oftentimes that's one reason we recommend a trust. Is if you put that money into a trust, it will be the best means of not only managing that money, but also distributing that money to who and whatever it is that your cousin desires to have with those assets.
Oh, here's the next question.
But then again, if your cousin is looking to go into a nursing home, we may have to look at putting in a Medicaid trust. But Sister Brantley, give us a call, schedule us for a free consultation so we can see what specific needs you have so that we can give a more specific answer to that particular question.
Awesome. Talia.
Go ahead and go to the next question.
Go to the next question.
Go ahead.
You can unhide that.
There we go.
What happens if you have a power of attorney and the person passed away?
Oh my goodness, these are some excellent questions.
Yeah, they did their research.
That is an excellent question. I'm so happy I get to answer that question because a lot of times we've had situations where when people don't have a trust established, they deal with this particular problem. So specifically what happens? Once the person passes away, that power of attorney is no more good. It's no use anymore. So a power of attorney is not going to protect you from probate court. Once that person dies, the bank is not going to accept that power of attorney. There's no one that's going to accept that power of attorney. In fact, what the bank is going to instruct you is you're going to need to establish a probate. However, if you've got a trust established, then you do not have to worry about that. You can provide the trust documents, or the bank will already have the trust documents, so you don't have to worry about the power of attorney passing away and you no longer having authority to do what it is that you need to do in reference to the assets of that loved one who has passed away. Because remember, once you've established that trust would dictate where that property or where those assets are to go.
And Talia Clear, I would suggest you give us a call too if you have a specific personal situation that you need a little bit more clarification or more answers, we can help you out too.
Yes. Again, if you want a free consultation, we ask that you go to our contact page and put in your phone number, your email address, and then we can answer any follow-up questions that you may have, and it will be a free consultation because our motto is to know better, you will do better. And so now we want to give you all the knowledge necessary so that we can do better in our future decisions. But great question so far.
Oh, here's the next one.
If three
people are on a power of attorney document, one person doesn't want to share information, how do the other two attain the information? It sounds like a similar situation.
We're getting these very unique and individualized questions here. If three people are on a power of attorney documents, one person doesn't want to share information, how do the other two attain the information? Oh, I would do this. How do the other people attain the information? Well, the first way that you could attain the information is contacting the person who is the authority of the power of attorney, whoever it is that delegates. So let's say your mom established the power of attorney and the three kids are now all on the power of attorney list. You can go back to your mom. If not, if you have a power of attorney and you require the information, provide that power of attorney document to whoever it is that you seek the information from, whether it is a bank, whatever institution you need that information from, provide that power of attorney form or documentation so that you can get the information that you need. Now, if you do not have the power of attorney, that's another problem that you're going to have, but you need to have a copy of that power of attorney to provide it to the institution. But also, we would hope that the family members would get together and provide the information. That's why we always in our power of attorneys, we have one person that's the lead, and then we have successor power of attorneys under them, under the motto, too many chiefs and not enough Indians.
So they're asking to put our number on the screen.
Yeah, our number is 321-800-5764. That's 321-800-5764. 321-800-5764. And just a reminder, in talking about power of attorneys, if you want to get a complimentary power of attorney, please go to our contact page and put in your first and last name along with your email address, and put in the message bar Mount Pisgah Legacy Wealth Seminar, Legacy Wealth Planning, so that we know that you are a part of the webinar today. Again, we would like to thank all the individuals who registered previously. We have their information, so they also are eligible for the free durable power of attorney as well.
Okay, so we'll take couple of more questions. And
do we have any more questions? Any more questions? Again, I hope this information has been informative. I hope that we have learned a lot from the information that we have provided. But most importantly, I hope that as you move forward, you would take the steps necessary to establish an estate plan for your loved one, or establish an estate plan for someone that you know. Remember, the problem a lot of times is that it's not a priority. The priority for Bill and Mary was to go on vacation. The priority for Bill and Mary was to plan for retirement. But what should have been number one on their priority list was establish the estate plan necessary to protect their kids. And that would have left them with the peace of mind necessary to make sure that their kids were taken care of without any issues. So again, our number is 321-800-5764. Thank you, Nydia. Says it was very informative and so important for our community, definitely. I think a lot of times what happens, and I'll leave with this, we often think that in reference to estate planning, well, I don't have enough money in my estate plan. But I think that's a fallacy.
Yeah.
Many of us do have enough money to indicate what's going to happen here or what's going to happen there. Many of us just have, a home. That's important. Come talk to us. We can talk to you about the specific need to help you with their information. It looks like we have a call coming in. Go ahead. We're ready to take the call. Miss Ruth. Go ahead, Miss Ruth. We're waiting. Can we hear you? It looks like we're having a little bit of difficulties with Miss Ruth. But again, if you have any questions or concerns, give us a call.
If Miss Ruth, you can give us a call, or you can put your question. You would be the last question. You could type your question in the dialogue box.
Right. And again,
give her a second or so.
We'll give her a second. Again, so listen, you may not think you have enough money to establish an estate plan or create a trust. You think you have to be extremely wealthy, but that's not the case at all. But you will never know unless you contact us, so we can look at your specific yes. needs to see what it is that you need.
And all of your information is confidential, kept confidential. So never don't have to worry about that.
Ruth was on mute. Can we unmute Ruth so we can hear her question? We'll try again. There's a question by Sister Tate. You mentioned taking estate through probate. You didn't mention being the administrator. Well, maybe the reason why we didn't mention it is because we don't advise. We want to avoid probate as much as possible. Now, one thing that's involved in probate, and you'll see this in the will, a will would indicate or dictate who is the personal representative. Now, who some state courts call administrator. Now, if you don't have a will and you die what we call intestate, then the courts would dictate who the personal representative is or who the administrator is. Now, that administrator is going to work with the attorney to send a notice to the creditors. We'll send to deal with any death taxes that are involved. It's going to have to go through and find out what are the assets in this particular estate and outline those assets to the court. So the personal representative is going to have a lot of responsibility if the court or if that particular case has to go through probate. Remember, a personal representative is only in the case of probate. An administrator is only in the case of probate. So what happens is somebody dies, and then that case goes to court, and the court establishes what we call the personal representative, who's going to be watching over the bank accounts and dealing with the affairs of that estate until that estate closes. And if you contact our office and you have to go through probate, we will walk those steps through you. We will work with you as we take the case from beginning to end and working with the personal representative. But again, remember, you can avoid all of that by having a well-funded and equipped trust, a well-funded and equipped family wealth trust. So if you know that a loved one has dedicated or indicated that they wanted you to be personal representative, I would call that loved one today and say, listen, let's create a trust so we can avoid all of this, and we can save you some money in establishing a trust that's going to avoid the necessities of a probate.
And just want to let our viewers know that you're licensed in the state of Florida, and all of this is directly specific to the state of Florida.
Yes.
There may be different regulations in different states.
As Dan said, I'm licensed in the state of Florida. So anywhere in the state of Florida, we can handle your estate plan. We can create an estate plan that is necessary for you and needed for you. It doesn't matter from as down south all the way to Key West, to Tallahassee, to Pensacola, to Jacksonville. So we can answer your questions and assist you wherever you are in the state of Florida. Again, I want to thank everyone for being a part of this webinar, this seminar today. I want to thank the production team for setting this up so that we can stream this to over 30 people. And we hope that this information has been informative. We hope that this information has been educational. And we hope that as you know better, that you will do better. Again, if you have any additional questions, if you have any additional concerns, if you have a specific, unique need to your individualized situation, again, we invite you to give us a call at 321-800-5764. And to get a free consultation, please go to our contact page and provide us with your information, and that would assist you getting a free consultation. And in addition, if you do register at our contact page, or if you have registered over Zoom already, you're going to be eligible for a complimentary durable power of attorney, and we will be contacting you this week in regards to that.
Thank you, Mount Pisgah. Thank you, Diana and Elder George Brantley, for letting us present this to your church and all the people you know. We definitely are excited and glad that you guys have tuned in. We're glad that we can help you out.
Thank you. So with that being said, we'll go ahead and have closing prayer. Dear Heavenly Father, we thank you for this opportunity to speak with your people. We ask that you would give them wisdom as they listen to this information and moving forward, that, Lord, any questions that they may have, that we'll be able to provide the answers for them. Lord, we ask that you would motivate them and strengthen them to make sometimes a hard decision, which is establishing an estate plan, Lord, and preparing for that day when someone or even themselves may pass away. Lord, we thank you so much that death is not the end, but we all pray and know that when all said and done, that you will call us to meet you in the air, that our future glory will be living with you in heaven. Bless everyone that's listening, Lord. We ask that you send a special anointing of your Holy Spirit power to be on them. Bless them now and forevermore. Let everyone say amen.
Just one more thing. They didn't know a little bit of background about you. They like talk about it.
Give us a call and we'll tell you some more about us. Thank you, everyone. Have a wonderful evening. All right, how long did we?